So on earnings call and proxy statement disclosure, there may not be as much direct ESG using the ESG terminology itself, but that doesn't mean the board's not thinking about these issues, which of course they should. But ultimately, whether they decide to lean in is now a more complicated picture than it was a few years ago.
Joining me today is Hirsh Ament, partner with Venable. Hirsh, thanks so much for joining us today.
Thanks for having me, Matt.
Now here at REITwise, you were on a panel focused on corporate governance issues. How did the 2023 proxy season go for REITs? And do you have any early insights on what the 2024 season might hold?
Yeah, so there were a number of significant matters or agenda items on the 2023 proxy season. Two in particular that I want to touch base on are the continued proliferation of ESG proposals. We saw quite a few environmental, social, and governance, slight increase in environmental and social, slight decrease in governance. By and large, these are not getting a lot of support, generally around 20%, and very few pass. We also saw a significant increase or an increase in anti-ESG proposals last year. On the same token, those have not been getting significant support either. It's important to note that even if they were to pass under Maryland law, a precatory proposal like an ESG proposal, there's no affirmative obligation on part of the board to adopt the proposal, even if it gets a majority support. The second item that I think was fairly significant in the 2023 proxy season was universal proxy. I know there were a lot of different predictions about what would occur, and you don't want to draw too many trend lines from one year, but I think what we can say is, at least in this first year, there was not a significant number of proxy contests. There wasn't significant amount more success, and similarly, there wasn't a deviation in cost from prior years. What we did see was a slight increase in nominees not being submitted because they failed to meet the requirements of the advance notice bylaws. And some of this had to do with, as a result of universal proxy, a number of companies have amended their bylaws to incorporate universal proxy within their bylaws and to make other governance enhancements as well.
And what corporate governance provisions are REITs, REIT boards, and REIT investors currently focused on?
Yeah, so I would say the big one right now is advance notice bylaws. After universal proxy, like I said a moment ago, we wanted to incorporate that within the bylaws to give a state law component to it as well. And in addition, to make other enhancements. I mean, sometimes these aren't revisited every year, every couple years, and there have been significant changes in communication and how stockholders make proposals. So we wanted to be clear here, and I think companies wanted to revisit to make sure the board and stockholders are getting all the information they need in order to make a determination with respect to dissident nominees.
And there have been several press reports that big institutional investors are stepping back from ESG concerns. How are REITs and their boards thinking about the increasing ESG polarization?
Yeah, ESG has definitely become a little bit of a political football over the past couple years. Whether it's ESG or before that, it was, corporate responsibility, and now there's some discussion about, transformational investing rather than using ESG. I think, boards and corporations need to pay attention to these issues and are paying attention to these issues. They are risk management items, environmental, social governance. They are, under the board's purview as part of its oversight responsibility. What I think we're seeing now is how corporations and management talk about these issues and how they decide whether or not to lean into these issues. So on earnings call and proxy statement disclosure, there may not be as much direct ESG using the ESG terminology itself, but that doesn't mean the board's not thinking about these issues, which of course they should. But ultimately, whether they decide to lean in is now a more complicated picture than it was a few years ago.
And finally, with the vast majority of REITs formed in Maryland, have there been any significant updates in Maryland corporate law that's relevant to REITs?
Yeah, so there was a significant case in 2023 called the Eastland Foods case. And what this case did was it reinforced in Maryland that the statutory standard of conduct, good faith, best interest, ordinary prudence, is the sole source of director duties. that there's no distinction between managerial and non-managerial duties, and that the business judgment presumption applies to all director actions. About 15 years ago now, there was a case that created some uncertainty around that in the context of a cash-out merger. The legislature had corrected that in 2016, but now this case confirms that the statute and 24051 is the sole source of director duties, which adds a lot of certainty and predictability for boards. And this can, in some respects, be juxtaposed with what's going on in Delaware a little, where they're having some interesting case law. You know, Maryland seems to be a very stable place right now.